Hey everybody, it's Chris Small, the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I want to talk to you about whether or not you can put additional assets into a trust. Before I get to that though, I want to remind you, if you have questions about this or anything else related to estate planning or probate, and you want to talk with us over the phone for free, you can do so by going to cmslawfirm.com. Okay, so this sort of came up in two situations today, different but the same enough that I thought I would talk about this today. And this is the idea of putting additional assets into a trust. So to sort of start at the beginning, I guess, if you have a revocable living trust, a revocable, which means you can revoke it, you can change it, you can amend it, you can update it, you can basically do whatever you want. If you have a revocable living trust, then you can put assets into and take assets out of that trust anytime that you want, as long as you are the trustor, right? The creator of the trust. You have the ability to do that, the option to do that. It's your trust. That's like the whole point, is to have that flexibility and control to be able to do those things. So that is the answer to that. Now, when we are talking about an irrevocable trust, which is a trust that is created by someone that is still alive but that cannot be changed, or is often created when someone has created a revocable trust and then they have passed away, the situation is a little bit different. And there are two circumstances that came up that are not, they don't cover every single circumstance out there in the world when it comes to irrevocable trusts, but there are two that are good enough to talk about today. So let's talk about them. The first that happened was there was an irrevocable trust that was created when someone died. So it was a revocable trust that was converted into an irrevocable trust when the creator of the trust died. That trust then had very specific distribution language for the beneficiaries. One piece of that distribution puzzle or pie or direction was that at some point in time, when someone reached a certain age, all of the assets were to be distributed out of the trust. In this particular instance, that person had reached that age, but the assets had not yet been distributed out of the trust because, quite frankly, the person that was the beneficiary wasn't that concerned about it, actually kind of liked the assets being in the trust and wasn't not too concerned about getting those assets right away. On top of that, the beneficiary received an additional inheritance from somewhere else, okay? And wanted to take that inheritance and put it into this irrevocable trust that was created essentially for them when this other person died. They wanted to know if they could do that. I told them probably not a good idea. First of all, the trust itself is essentially complete, right? The assets should be distributed according to the rules of the trust. The solution there is to receive the distribution, to create their own separate irrevocable trust, grantor trust essentially, and move those assets in there, name the person that they want to as the trustee. They can remain the beneficiary and they will still have those same benefits, the same benefits that they want. But they have one added benefit. I'm using the word benefit a lot today. There's one additional consideration there, and that is when you create your own irrevocable trust, you get to decide where the assets go when you are gone, if you are the beneficiary. If you name other beneficiaries, then you can also determine where those assets go after those beneficiaries are gone. So creating your own irrevocable trust provides you some discretion with what happens with the downward distributions, okay? That is the first sort of type of irrevocable trust situation that we're speaking of. The second one is actually sort of very similar to the back end of that conversation. Someone created an irrevocable trust, grantor trust, and they were they did it to put a very specific asset into this trust for reasons that I'm not going to tell you because, you know, attorney-client privilege. But they did create this trust. It is an irrevocable trust at the time it was created, and they were wondering if they wanted to move additional assets into this trust over time, could they do that? And the answer is yes, you can. The only thing that you need to take into consideration, well, two things that you need to take into consideration when you do this. A, anything that you move into an irrevocable trust like that is going to be considered a gift to the trust. This is very important because you are not going to get a step up in basis if you put real estate or stocks or other things like that into a trust like that. The gift is going to retain the original basis. If that stock or real estate or anything is ever sold, the gain will be from the original purchase. That's number one. The second thing to remember is that if you go over $15,000 per person, per gift in a calendar year, you're going to have to file a gift tax return to show the IRS that you have made a gift in this manner. Okay? So the answer is different depending on the way that the trust was created, sort of the status of the trust. But all in all, most of the time, you can add new property to a trust, whether it is revocable or irrevocable. There are sort of different consequences or different things that happen when you do that, depending on the type of trust that it is. Before you put anything into a trust, I would highly encourage you to talk to an estate planning attorney just to make sure you're not doing something dumb, or you're not doing something you don't want to do, or there are no unintended consequences. Okay, so that's it for my trust talk today. Hopefully you enjoyed it. If you did, there's a little like button somewhere around there. Hit the like button. Okay, if you are someplace you are listening and you could subscribe, hit the subscribe button. You don't want to miss this fun 3 times a week or so. Hit the subscribe button. And again, if you have questions or anything about anything related to estate planning or probate, and you want to talk with us over the phone for free, you can do so by going to cmslawfirm.com. Okay, that is it. As always, I am Christopher Small. I am the owner of CMS Law Firm. We do estate planning. We do probate. We do it well. Thank you for your time. Thank you for your attention. I appreciate you, and I will talk to you again soon.